Hello, thank you for clicking on my video. Whilst I've been stuck in lockdown, I've decided to do a short course called Patents for Non-Patent Attorneys, which is looking at going through some fairly high level stuff on patents, so that if you've got no knowledge really about patents and you'd like to get some, this is the course for you. Really aimed at people who perhaps have invented something whilst you've been on lockdown, or maybe you own a business or you're an engineer or a manager within a business and you'd like to patent something you're doing. Alternatively, maybe you'd like to do some business with people who've got patents but you don't really know what that's about, what you can and can't do. This is the course for you. So this is the first of 3 videos, obviously called Episode 4, A New Invention. Before we jump in, let me just introduce myself. I'm Gemma, and my LinkedIn details are given there. Please do feel free to link in with me and ask some questions. I'll be happy to answer anything I can, or just link in with me. It would be lovely to have some more links. So over the course of the course, I'm going to be talking about a number of subjects at a fairly high level to get you introduced into the main issues that we face within patenting. So today we're going to be looking at what can be patented and where patents can be obtained. In episode 5, we're going to be looking at how much it costs, how long it takes, how long do patents last, why bother in the first place, and do you really need to hire an expert? Episode 6 will then look at issues about infringement, how you enforce patents, what about other people's patent rights, freedom to operate type issues. Are there any other forms of IP protection that might be useful to you, like designs, for example? Other options that might be available, and then finally some other things which might be useful to you if you're working in the innovation space that you might not know about. So as I mentioned, today specifically we're going to be taking a look at what can and can't be patented and where you can obtain patents. So before I jump into the subject of patents more specifically, I just wanted to mention something that seems to me to be a little bit of a misunderstood thing generally, which is what IP is and what it protects. Quite often on the news I might hear, for example, oh, so-and-so has trademarked their new invention. Well, no, they haven't, because trademarks don't protect inventions. Patents do that. Patents protect how things work. Generally speaking, there are 5 types of intellectual property or IP protection, which are patents, designs, trademarks, copyrights, and trade secrets or know-how, that sort of thing. So that's just summarised very quickly on this slide. Intellectual property, generally speaking, is made up of patents, trademarks, designs, copyright, and trade secrets. We're going to be focusing very much on patents, but in episode 6 I will come back and mention a few of the others. Now, I ordinarily include this example of a patent application when I'm presenting to audiences to get a bit of a laugh, but it actually does demonstrate something quite important, which is that patents can be obtained for things which are really quite simple. You don't have to be working at the very cutting edge of all known science, provided that you have done something that's new and it's inventive enough, which I'll go on to talk about more, then you can probably get a patent for it. So the very first test for patentability is novelty. That is to say, is your invention new? Now that is assessed by, has your invention been disclosed to the public anywhere in the world by any means whatsoever, including written publications, use, videos on the internet, that sort of thing. The point that I really want to get across about novelty to you is that this includes your own publications. It doesn't matter that the information originated from you. If you have disclosed, you've lost your novelty and you will not get a patent. So that would include, as I've mentioned before, marketing material, bringing people to your factory to see your invention, or use in public, amongst other things. Now, clearly there are going to be times when you need to disclose an invention before you've been able to get a patent application on file. Normally that would be when you're trying to raise funds, perhaps from a venture capitalist or other sort of investor. So you can disclose your invention before your patent application is on file, but it must be done in a confidential way so that the person receiving the information is fully aware of exactly what it is you're disclosing and the fact that is confidential and is not to be shared with anyone else. Ideally, use a non-disclosure agreement, which can be found on the web, to be honest, but ideally it would be far better to employ a solicitor or a patent attorney to draft you something specific to the situation. There's no guarantee, even if you've got a signed non-disclosure agreement, that the person concerned won't just go off and disclose your invention to somebody else. But if they do, at least you have some grounds to write to them and say that shouldn't have occurred and now you'll want to sue you. Can you afford to do that? Who knows? There are provisions which might help you to get a patent in certain territories around the world if a third party has disclosed your invention without your permission, and the existence of a non-disclosure agreement might help to prove that. But generally speaking, you want to avoid it at all costs. It's very expensive. It is going to add a great deal of complexity to the whole process. So the rule, if it can be followed, is file a patent application before you disclose to anyone. If you can't, be extremely careful about who you disclose to and the circumstances of that disclosure. The second test for patentability is inventive step, which is to say, is your invention an obvious development of what's gone before, or is it a non-obvious development, in which case there is an inventive step. This is assessed relative to what we know as the prior art, which is the state of the art on the date that you file your patent application. Nothing published after that date will be taken into consideration, so you don't need to worry about that. Now, clearly, this is very, very, very subjective, way more subjective than novelty, which tends to be a little bit more black and white, although we can argue about it. As a patent attorney, I spend a significant amount of my time arguing back and forth with patent examiners over whether or not something is obvious over the prior art that's gone before it. I will endeavour to obtain as broad a scope of protection for my clients as possible, and the Patent Office won't necessarily aim to limit that protection. They will just want to be sure that what's going to be granted is valid. But the main key point is that inventive step is extremely subjective, and you're going to get different answers depending on who you ask, and that is particularly true when you start to think about obtaining patents from different patent offices around the world. Final point is, to be patentable in most countries, an invention has to have industrial applicability. Really the only time I've ever seen that come into play is if somebody has decided that they want to try and patent a perpetual motion machine, for example, in which case they'll have lack of industrial applicability thrown back at them. Generally, it's not something you're going to need to worry about. Before I move on to things which specifically can't be patented, let me just apologise for the changing light. I'm in my own bedroom, desperately trying to find somewhere quiet in the house during lockdown. I've got my husband, my dad, my 2 kids and my dog here, so it's very, very hard. So the reason it's flashing black and white is because there's a big tree outside my window and it's being blown around, so apologies for that. Anyway, moving on. There are certain things which, as a matter of statute, as a matter of policy, cannot be are not inventions, so cannot be patented. They include methods of treatment or diagnosis of the human or animal body, computer programs, mathematical methods, methods of doing business, rules for playing games and scientific discoveries, and anything which is considered to be contrary to public order or morality. Now, I will talk about a few of these in more depth, but as an overarching point, the statute says that these things cannot be patented as such, which means that if you claim them, so if I write a claim that says a method of treatment of the human body, it's going to be disallowed, but there are ways and means of getting around some of these limitations. So let's begin by looking at this exclusion of methods of treatment or diagnosis. As I mentioned, if you claim that as such, you're not going to get the patent granted, but things that can be patented in that space are medicines and methods of making medicines, new therapeutic uses of known medicines, all sorts of medical devices, and anything that's purely a cosmetic treatment and doesn't have any medical aspect to it. Now, I'm an engineer, and this is not my area of speciality at all. I'm not going to say it is. This is definitely one area. If you are making inventions in this space, you need professional representation. By carefully looking at what you've done, identifying the core inventive concept, and by some really expert claim drafting by people who know what they're doing, you're going to be able to get the best protection possible for your invention in this space. So the next exclusion I'm going to look at is the exclusion to patenting computer programs. Again, if you claim a computer program as such, you're not going to get a patent, but there are certain aspects of computers and computer programs that can be protected. If your computer program achieves a specific technical effect, for example, improving processing speed or decreasing energy usage, or perhaps controlling some external physical system, then it's possible that you could get a patent granted for that. Similarly, computer implemented inventions, so that would be some sort of process which as part of that process involves a computer or a programmable apparatus of some sort. If you're looking to patent the whole system, which includes that computer or computer program, then it's possible that you'll be able to get a patent. As a rule of thumb, if the process that the computer program is carrying out could just be carried out by a human or a group of humans, albeit a lot slower and perhaps less accurately, if it could be done in that way and all the computer program is doing is automating that, then you're probably not going to be able to patent that type of computer program. Computer software generally is protected by copyright. So that brings us to the end of the section on what can and can't be patented. As I said at the top, if you have any questions, please get in touch with me via LinkedIn and I'll do my best to answer you. If it's got anything to do with medical inventions, I will pass you on to one of my most excellent colleagues. But please get in touch with me and I'll be happy to either answer your question myself or pass you to somebody who's more of an expert in any particular area. So next I'm going to move on to talking about where and how you can get patents around the world. As this slide so beautifully demonstrates, patents are territorial. There's no such thing as a worldwide patent, and as things stand at the moment, if you want global protection, you're going to need a patent in every country. Fortunately, that's almost never necessary. So as I mentioned in the previous slide, there's no such thing as a worldwide patent, but happily you don't need to file in every single country that you'd like to have protection in all at once. There are systems and ways of spreading things out so that you can raise more money, have a better idea of whether or not your invention is going to be commercially successful or whether or not it's even patentable. So I'm going to look at a few of those specifically. I will look specifically at the Patent Cooperation Treaty, which is the PCT, often called an international patent application. And I'm going to look at the European Patent Convention as well. I'll look at those two in detail. Other systems exist, ARIPO and OAPI, which is for African countries, EA for the Eurasian countries, and the GCC states as well have methods of getting patents without having to go into each country individually. So just before I go into giving you a specific sort of run through example, I just thought I'd put up a quick map showing which countries shown in blue are part of the PCT system. So if you file an international patent application, you will eventually have the option to obtain a patent in any one of the countries shown in blue. And then this map shows the countries which are part of the European Patent Convention. The really key thing to note here is that the European Patent Convention is absolutely nothing to do with the EU. Britain is and will remain a member of the EPC after Brexit. You can see that Norway and Switzerland are there as well. They've always been there. So just to clarify that the European Patent Convention system of obtaining patents will be available to you both now before Brexit and after Brexit is complete. So on this side, I've hidden myself because I will block out the bottom right-hand corner otherwise. So what I've given you here, and I'm going to talk through it quite slowly, is an example of what you might do if you've made an invention here in the UK, for example, and you eventually would like to obtain patent protection in a number of countries around the world. So down the left-hand side, you can see the time intervals. So at t equals 0, that's your priority date. That's the date you file your first patent application, typically in your home country. So if you've invented something in the UK, ordinarily you will file your first patent application at the UK Patent Office. Once your UK application is on file, a number of things will happen in the first year. Most notably, you will get a search report, which the Patent Office will indicate to you any prior art that it has found which is relevant to the novelty and or inventive step of your invention. You can choose to respond to that or not. I'll talk about this in much greater detail in episode 5. But just thinking on this slide about the process of going from your first filing through to a number of granted patents, the first thing you have to do in that respect is at 12 months, which is the end of your priority year. Now, the concept of priority date and priority year is extremely important. Basically, you have 1 year from the date of your first filing to file patent applications anywhere else around the world, which will be treated as though they were filed on the very same date as your very first filing in the UK. That's important because if your later filed patent applications for the same invention don't have your priority date, you're going to get into a sticky mess when it comes to novelty. So it's absolutely crucial that you take advantage of that priority period if you want to obtain patents anywhere else around the world. Now, fortunately, you don't need to get to 12 months, which we all know actually is a really short period of time, and decide that you want to file patent applications in perhaps another 10 countries. That's going to get very expensive very quickly. But we have the international filing system, the PCT, which is essentially a sort of a holding card. You file another patent application which claims priority from your first UK application. Both of those applications can run in tandem alongside each other. Most people choose to do that, but if you want, you can drop the UK with a view to re-entering the UK once you get to the end of this process. But what you really bought for your international patent application at 12 months is another 1.5 years, so 2.5 years in total, that's 30 months, before you have to make any decisions about which particular countries you'd like to obtain patent protection in. During that time, you will receive another search report from the office which is acting as the international searching authority, which may repeat what came out of the UK search, but quite often it will come up with different prior art, which will give you and potentially your investors a better idea as to the likely success and likely scope of your granted patent. Once you get to the 30-month stage, or the 2.5 year stage from your very first filing, you do then need to split this international patent application into separate countries and or separate regions. So let's take, for example, the USA, Australia and Europe. What you would do is you'd need to file directly in the USA, you'd need to file directly in Australia, but for Europe you'd be able to file a European patent application which would go through the grant process as one single unit, and it's not until the thing is accepted for grant that you actually then need to divide it into separate national patents. People are often very, very interested in how long it takes to get your patent granted, and I'm going to talk a little bit more in episode 6, I believe, about why you shouldn't really get hung up about grants. But just for the purposes of this video, 3 years would be extremely quick from your original patent filing to your first grant in whichever country that might happen. 6 years might be more typical, but it's not unknown for it to go far beyond that. But as I said, not something you should get hung up on, which I will explain in episode 6. So I'm back. Hi. We've now reached the end of the first video. Thanks for watching. That was episode 4, A New Invention. In the next episode, episode 5, the Patent Office Strikes Back, we're going to be getting down to the brass tacks and looking at how much all of this will cost and how long the process will take throughout the various stages. So I'll see you then. Bye!